the offender. So that's where the tort law system comes from. Now, I recognize, as many of you, that today's tort law system is too expensive, it takes too long, and sometimes it doesn't always produce the right result. But we do have a system that attempts to be a rule of law-based system of justice. Is it perfect? No. It's nowhere near perfect. But I think, to paraphrase Dr. King a little, Martin Luther King Jr., the arc of justice tends to go in the right direction. So what we try to do is we have the adversarial system. And the adversarial system says if you have a claim against somebody, you file a lawsuit. And when you have that claim, somebody has to defend it. And there's usually, although not always, lawyers on both sides representing their interests. Sometimes corporations will be represented by big firms. Sometimes corporations will be represented by in-house counsel. There are plenty of good, solid personal injury attorneys. The personal injury attorney has to some extent taken a hit from time to time as to reputation, partially due to the so-called ambulance chaser, which is actually unethical. If people are doing stuff like that, if you're hiring people at the hospital to pass out your cards, you will quickly be disbarred by the Virginia State Bar. They will not tolerate stuff like that. So there are all kinds of rules, and there are some personal injury attorneys who have a very stellar reputation, and there are some personal injury attorneys that their reputation is less than stellar. And I think the rise of advertising in the legal profession and some of the silly ads that people see, I don't think has helped the profession. I think it's hurt it. But when we talk about tort reform, we have to ask ourselves the question, who wants tort reform? And what reform is necessary? Because there's some good things that probably everybody can agree upon. But the tort reformers who came and they talked to Tea Party groups and things like that, that tort reform group, and I met with them briefly over lunch one day. And it was a very, very animated discussion. I came away with a greater respect for them. I hope they came away with great respect for me. And even though, as I said, I'm a member of the trial lawyers because it's good business for me to be a member of the trial lawyers, and I'm a member of the Virginia Bar Association, and I'm required by my license to be a member of the Virginia State Bar, and I'm a member of the Old Dominion Bar. So you see, I'm a joiner. I'm joining a lot of things. And part of the reason for that is because I want business for the company from all of those people. The tort reformers are primarily sponsored by business and corporate interests. Is there anything wrong with that? No. Thank God. We have a free country where we can band together, whether we're liberal or conservative or libertarian, we can band together and push for political goals. But we always have to be careful with the stuff we read, that we are not being taken in by those who want to tilt the scales of justice in a certain direction. That is something I would stress to you. These corporations do have an interest in getting rid of as many lawsuits as possible. Not just the ones that don't have any merit, but they would like to get rid of the iffy ones that might have some merit. They probably can't get rid of the ones that have a lot of merit because they're going to work their way through the system. And in fact, many of those cases will settle. Because if one side knows that they have great exposure and there's a decent chance that the other side's going to win, there's going to be a great interest in settling that case before it goes to court. So it's a fair question to ask, what is the motive of the tort reformers? Now, you can ask the question, what's the motive of the trial lawyers? Well, I'll tell you what the motive of the trial lawyers is. It's huge fees. No question about it. They get a contingent fee. Now, I will tell you from my years of practice in the law, is that I would get some cases, and I never did have a large, huge $1 million. I once defended a $1 million case on appeal, and thankfully we won at the Supreme Court, the Virginia Supreme Court. But my cases would tend to be $5,000 or $10,000, $15,000, and you added up the meds, and you kind of multiplied them, and you looked at their lost wages, and you decided even things like how attractive the case was and how attractive the person is. And I don't mean attractive in a supermodel sense. I mean attractive in the sense of, do people like them? Are they likable? Most of you in this room would be likable. But some of you might be a little more likable than others, let's say. But you might be representing somebody that say has a little bit of a criminal record, or maybe has a lot of tattoos on their arms or something, or they are a motorcyclist and they've got some reckless drivings in their past and stuff, and so they're not as attractive to bring to court. And all of that factors into the questions of settlement. And eventually you'll work it out with the insurance company. There would be cases sometimes where I would look at the case and I would write the letter and I would send the meds in, and they would give me everything I asked for. And I have to tell you, whenever the insurance company gave me everything I asked for the first time, I always shook my head and said, I didn't ask for enough. That's right. So, but those, and they are potentially lucrative, but sometimes you have to work very hard to get to a point where they will eventually settle the case. Because we have in Virginia is one of 6 states, as far as I know, that still have what's called contributory negligence. Assumption of the risk. They have contributory negligence and they have assumption of the risk. What are those? Contributory negligence means simply that if you were partially at fault in causing the accident, you cannot recover. Vast majority of the states and some of the federal government, if you have a railroad claim and it falls under the Federal Railroad Act, it's not contributory negligence, even if state law calls for contributory negligence, because the federal law is going to apply. Most states have comparative negligence, and some states have different types of comparative negligence. And how does comparative negligence work? Basically, you decide if somebody was 70% negligent, and if the other party was 30% negligent, they're the plaintiff, they're trying to bring the suit, they're the defendant, they're defending the suit, they're 70% negligent. What happens is that you figure out what 100% would be and you take 30% off. So it goes to the recovery. We don't have that in Virginia. Now, it is true. There's a great deal of speculation that even Virginia juries tend to go back into the back, even though the judge tells them not to, tends to go back into the back and do something like comparative negligence in determining what they should get. There's a lot of defendants' verdicts in Virginia. There's a lot of contributory negligence, in suits, and defenses, and assumption of the risk is where I know I have a known risk. It's venturous, it's out there, and yet I do it anyway. And so basically, I'm saying that can be a bar on recovery. So we have a lot of, and in fact, we are one of the most business-friendly states for the court system of any. So let's talk about what the tort reformers wanted, and then let's talk a little bit about what the tort reformers got, which actually was very little. Some of you might be disappointed in that, but they wanted summary judgment reform. I'll come back to that. I'll come back to what each of these are. Venue. Venue is where a suit is brought. Summary judgment, as it is implied. It's a summary judgment. It's a judgment by the judge before the jury hears the case. Venue reform. They want where a suit can be brought. Service of process. Service of process is I bring the papers and I hand them to you. That is service of process. Non-suit is the civil version of what a prosecutor does when he or she nully processes a case. It stops the suit. They have to go back to the beginning. In Virginia, there is one free non-suit, but there are some stipulations associated with it. And then finally, there was something that I think everybody ended up going to agree with, and that's property rights and trespass reform. So those were the things that the tort reformers wanted. What they wanted for the summary judgment was this. 49 states allow the use of what is called a deposition. Most people don't know what depositions are, except unless they've been in a lawsuit, because I didn't know what a deposition was until I went to law school. Some of us who are particularly savvy about our history have depositions. Remember the famous Paula Jones deposition. The whole thing about Bill Clinton started out because it was a civil case brought by a woman named Paula Jones. She had to go all the way to the Supreme Court to have the Supreme Court decide that the president could in fact be sued. Then it went back down to the district court. In fact, it was done by a lawyer right here in Virginia named Gil Davis. And a legal team, there was a whole slew of people. There was some Arkansas lawyers. Gil Davis was the local, because it was brought in Virginia. And so they had the, now then they were actually able to bring the President of the United States in under oath. Isn't this great country? And they had him swear an oath that everything he said was true. And because of some things in there that weren't true, or allegedly weren't true, that led up to the Kenneth Starr and eventually impeachment and all of that. But it started out with this deposition. So a deposition is basically, if I was deposing Major for something, I would have him here, the court reporter would be here, I would ask him questions. Sometimes that gets a little hostile because you're trying to establish from the other side that they ran the red light or that they weren't careful in how they kept their store or something. So you're trying to establish that, and they're prepping their person to try to kind of block what I'm doing. So you have this long-winded situation, and it gets reduced to a transcript. And that transcript in 49 states can be used to get a summary judgment in certain situations. Now, the law sounds very good. Summary judgment's only supposed to be granted if there's no dispute as to what the facts really are, and there's no way that one of the parties should win. The other party should win automatically. Now, you would think that would be a good thing, and to some extent it is a good thing. It probably does prevent a lot of litigation. It probably does prevent a lot of unnecessary trials and that type of thing. Virginia is the only state that does not use as a general practice the deposition to determine a summary judgment. And what happens is that in most of the other states and in the federal system, they have what's called an appeal of right. Meaning, if the judge decides before there's even a trial, if the judge then decides, yes, I'm going to award judgment to the defendant, and he wins, it wins, the plaintiff is, of course, going to appeal. And it works the other way. If plaintiff gets a summary judgment on some issue, you can have a partial summary judgment. The defendant can appeal. We don't have automatic appeals in Virginia. We do almost all of the civil appeals go directly to our Supreme Court, and they're done by petition. Now, I think we have a fabulous system of justice in Virginia because I think they look at those petitions very carefully. However, it's still not an appeal of right. You go, file your petition, they file a brief in opposition. I print those things, so I see a lot of them. Some of them are very, very, very good, and some of them, well, we will clothe that over with the veil of mercy. But it is a justice of the Supreme Court will look at the petition. They will decide whether they're going to grant that petition immediately or immediately right after the pleadings are filed immediately. If they decide, no, they're not ready to grant this petition, it only takes one justice of the Supreme Court to grant the petition. Unlike the federal system where it takes 4 to grant certiorari, at the Supreme Court of the United States, it only takes 1. But then you go before a panel of 3 justices. I've done it many times. Civil cases, criminal cases, the whole line. And you try to persuade one of those justices that this case should be heard. All you want is you want the case heard. Certainly they're not going to grant appeal if they think all they're going to do is just keep going what was going. So to some extent, they've had their appeal, and if you want to call that an appeal of right, you can. But that's not what the lawyers would call an appeal of right. An appeal of right is what happens if the petition is granted. Then you have briefs, and you have a full argument before the whole court. I've done that too. And then you get a decision, which is usually, although not always, written down, and then it becomes a precedent. Those common law judges have established another precedent that will be used by lower courts and will be used by the Supreme Court, Court of Appeals too, in future cases. So, because we do not have that, we have to be very careful. The 7th Amendment to the United States Constitution says trial by jury is the mode. For every dispute over $20, there's trial by jury. Now, they have interpreted, the Supreme Court of the United States has interpreted the 7th Amendment to mean that the trial by jury has to exist as suits at common law. And so therefore, there are many, many, many statutory suits where you only get a trial by jury if the statute calls for a trial by jury. But That's what the Constitution says. The Constitution of Virginia says trial by jury is favored over every other form of dispute resolution there is. We prefer it, and we state that in the Constitution. So when you make it easier to get summary judgment, you are making it easier for the judge to make a determination. Now we know judges are a creature of the political process. That's not to disparage judges. Matter of fact, I think that considering all of the things that go on in Richmond, we end up with the vast majority of our judges are very good judges. You hardly ever hear about a Virginia judge taking bribes. You hardly ever hear about a Virginia judge being corrupt. You hardly ever hear about, there are people who even in the Tea Party movement, who would disagree. They would say, judges are corrupt and they're perverting justice and all of that. I don't believe that. As a general rule, I don't believe that. Now, is there a lot of, I think in the political realm, I think there's a lot of, I'll scratch your back if you scratch mine. But judges, I think the robe can and does change a person. It makes them realize they are no longer a partisan. They're not a prosecutor anymore. They're not a defense lawyer anymore. And they need to be the impartial judge. And I think we should be thankful to that. We should thank the Lord. And we should pray so that we continue to have good men and women involved. And I think the judicial process in Virginia does not get the attention it deserves. But that's another story. But judges tend to be oriented in certain directions. You have some judges that are a little bit towards the plaintiff's side. Maybe they came from the plaintiff's bar originally, and that's their orientation. And you've got judges that are a little bit towards the defense bar. Maybe they worked for a firm that represented large corporations. As they knew a lot of political people, they went to the district court bench or the circuit court, maybe even the Court of Appeal Supreme Court eventually. But the judges are, we have good solid judges, but they come to, like everybody else, they come to the court with certain understandings about things. So, if you have a summary judgment, the jury doesn't get to decide. Unless an appellate court says the judge was wrong. So, I'm very skeptical about putting in the depositions. And what ended up happening is that you had two strong forces. You had these business, like the chambers of commerce and that type of thing. They were really pushing hard. You had the trial lawyers that pushed back. Now, I want to correct something. There's only 26 lawyers in the Virginia legislature. There's 140 legislators. And I'm told there's only 26 lawyers. Now, there may be other members of the legislature who have a legal background and they don't practice law. They haven't practiced law. They're working for a company, or maybe they have their own company, and they just happen to have a law license. For example, Delegate Peace, I think, just opened a law office. He's a lawyer, but he doesn't have a law practice in Virginia up to this point. I think I just read that he's trying to start one or thinking about starting one. So it might be 27 now. But, in fact, the House Judiciary Committee, the House Courts of Justice Committee, and the Senate Courts of Justice Committee do not have an entirety of lawyers in their membership. That means the people who decide who's going to be judge and legislation are not all attorneys. So, yes, in fact, they were very, very worried. The trial lawyers were very, very worried. So they came up with a compromise that they thought everybody could live with. And here's what happened. The summary judgment bill became that there was a rule that said when a lawsuit is filed, there's a determination made, shall we fight the lawsuit on its face? Is it clear on its face that it states what is called a cause of action, a suit? If not, they might fight it with the court at the very, very beginning. But if they don't, or whether they do and they lose, it goes to the next stage, and the next stage is discovery. Deposition is one part of that. You can ask questions under oath, written questions, there's written interrogatories. There's something called a request for admissions. Now, requests for admissions are designed to basically say, for example, on December the 26th of 1944, which say that's the date of the accident, it was a snowy day. We kind of want to rule all that out, We don't want to have to fight over things that are obvious. So they come up with something called a request for admission. So some enterprising lawyer said, well, let me turn all these discovery depositions into requests for admissions. I can ask the questions, I can make them admit or deny, here's my deposition. Well, the court said, no, you can't indirectly do what you can't do directly, which is use the deposition. Well, the law's now changed. You can now use the depositions as the basis for the request for admission. By the way, there's a limitation on the number of questions, on the number of these written interrogatories that you can ask. Don't know if there's a limitation on request for admissions, but there's a limitation. So, and there's also a limitation. You usually only get one try at deposing somebody. You better get all your questions answered that one time, because unless the court agrees, you're not going to get a second try. So there are protections in the law from unjust harassment and calling people away from work for days and days and days and days and that type of thing. And we don't do like California, where they have a trial for 20 minutes and then they adjourn to the next day and so forth and so on. We do our trials. They move through pretty fast in picking a jury. We just don't have a lot of the fooling around that you see. We should be thankful. We should be thankful for that. So the summary judgment reform basically is you can do the depositions. You can use them for requests for admissions, but you can't. Okay, but and I appreciate that. Thank you. But you can't use the, and that's the main, and the summary judgment is the main point. So they did not get what they wanted, which was they could use the depositions. And I just want to say, if you have depositions and you're going to use them, the judge has got to read them. That's going to take time. Our judges generally don't have a lot of support staff to help them take care of those, to help him or her take care of those things. So we don't have it. Another useful thing that actually was a useful reform is the venue. So what we did is we said no depositions, but we can use requests for admissions, and you can use depositions to determine if punitive damages are appropriate unless it is a case involving a DUI. So basically that's what they did. That's what they came up with. Now the venue reform I think is a good thing, because venue can be abused. Venue is where the suit is held. And as we know, some jurisdictions pay out more generally than others. And so if you can get the city of Portsmouth, if you can get the city of Richmond, you want to get your suit in those cities. And there was a particularly unjust case that was decided a number of years ago where a deacon who had an automobile accident in Henrico County, which is a lot more conservative than the city of Richmond, they wanted the plaintiff, instead of filing the suit in Henrico, filed the suit in the city of Richmond. And the reason is because he was a deacon in his church, and his church was in the city of Richmond. And he went frequently, because he's a good deacon and he was conscientious, he went to church, to these church meetings in the city of Richmond, and they said because he did substantial business in the city of Richmond. Well, his business was deaconing. That had nothing to do with the accident. The court said, no, the city of Richmond is the proper place. And I didn't think that was fair at all. So now they've tightened that up a little bit to try to make it more, it's going to be where the accident is, more often than it used to be. Now, the non-suit, a lot of people wanted to put some severe restrictions on the non-suit, but let's go back to what we're doing in a suit. Sometimes due to situations beyond the plaintiff's control, something happens. A witness is sick, or a witness dies, or somebody is not available for some legitimate reason, and sometimes you just cannot get the court to give you a delay, called a continuance. You have to have the right to say, okay, I'm going to dismiss my suit and I want to bring it back. To avoid abuse of that, there is some restrictions. There are some understandings about paying if there's like expert witnesses and stuff that you have hired and you're about to go to court and that type of thing. So I'm glad to see that that's been tightened up a little bit. But the tort reformers, I think, wanted to go a lot further down the line. The trespass liability is something that I totally agreed with the tort reformers on. And that is, there's no duty of care to a trespasser except in those circumstances where a common law right of action or a statutory, a written out law right of action, or a judicial exception existed as of July the 1st of this year. So, the tort reformers got very, very little of what they wanted. I think that's a good thing. There's always opportunities, and we need to always be concerned about these issues. But I would ask people to remember, we are dealing with a system that is designed to bring justice to all. And if we tilt the scales too much in one direction or the other, what's going to end up happening is either people who have legitimate complaints are not going to get compensated, or you're going to have frivolous lawsuits. We don't want either of those. So we want to try to come up with ways to prevent that. Virginia's a really good state to do business in, and I think businesses recognize that. And we want to keep it like that. So I would ask the Tea Party people not to necessarily just go right on along when the tort reformers say, we want you to do this, this, and this. You want to ask two questions. What groups are you representing and why? And two, what do you want to do and what's the ultimate ramifications? And it never hurts to ask a lawyer. Is there any questions? Yes.
Could you clarify real quickly the trespass change that you were talking about there?
What they basically said is that we are not going to adopt the more liberal standard of the American Law Institute. We're going to keep the law exactly as it was as of July the 1st of this year. So we're not changing the law. We're indicating we don't want to change our law. The American Law Institute wanted to have a much more liberal standard where trespassers would have all kinds of rights and stuff like that, even though they're trespassers. And so it would have increased the liability of businesses and landowners.
So property owners' rights were upheld.
Yeah, that's right. That's
okay.
Exactly right.
That's
They deliberately wrote it so as not to change the law as it is.
Lonnie?
Good.
Yeah, I was just wondering, you use the term business friendly, and at what point does business friendly become consumer be damned, which I believe there's quite a bit of that. The consumers have virtually no protection in the state of Virginia. It's at your own risk, the buyer beware. And
Well, we do have a business friendly, but I will say this about consumers, and that is we have a really good consumer protection statute that protects us from false advertising and the like, and there's a lot of issues with like spas and things like that. And then we have an excellent lemon law, because the person wrote the lemon law and it was at that time kind of a trailblazing situation. And we have an excellent lemon law. So we do have some protections for consumers. I agree that there probably is not as many protections as we need, but let us always remember that when we are calling for the government to do something or the courts to do something, we are calling for regulation. Some regulation is necessary for health and safety, but some regulation isn't necessary. So there always has to be a balance because that regulation affects businesses, because it affects how they do their advertising, and it affects how they run their business and that type of thing. So we'll always have to have a balance to try to make sure that neither side loses ultimately in that. Yes?
What's the biggest misconception of tort reform?
I think the biggest misconception is that you can go outside and stub your toe and win $1 million from the American Legion. I think that is the biggest misconception around, is that there's frivolous lawsuits and you can get real money. Now, I am not going to speak to the other states of the Union because I don't practice law in all those other states. But I'm telling you, in Virginia, juries don't like to give big verdicts. They will give a big verdict if somebody's really been hurt or their rights have really been violated. But they don't usually like to give big verdicts. They're very conservative. And they generally, and they're going to scrutinize these things very, very carefully. And it's not uncommon for there to be a defendant's verdict. So,
One more question.
Sure.
This is from the Family Foundation. This report on General Assembly and issues pertinent to the Family Foundation.
Okay.
And is there such a report coming on tort reform?
Well,
who voted for what
there probably is, and you can probably get two sides to the story. You can probably get the tort reformer side of it, and you're going to get the trial lawyer side of it. And I would just say, go to the Virginia Trial Lawyer Association webpage. They might have something, a legislative to-do list, and the tort reformers may as well have a legislative to-do list. And there are federal legislative to-do lists and state legislative to-do lists.
Questions?
Yes.
What about the concept of loser pays?
Yes. Well,
Discuss the pros and cons.
yes. Okay, I'll just briefly. In the British system, loser pays happens quite often. If you go to court and you lose, you're going to pay the attorney's fee for the other side. Now that sounds fair until you think about somebody's got to win and somebody's got to lose, and that doesn't mean necessarily they didn't have a valid claim. It just means for whatever reason they lost. Now, the American system is each side pays their own attorney. There are riddled with exceptions to that. If you have a statute, if you have it in contract, there's a lot of contracts where they say, you know, if I lose, you pay your reasonable attorney's fees. That's usually in a contract for the sale of a house, for example. So there is some loser pays in the law, but it's by contract or by statute. The civil rights statutes have that. So, but I think a general loser's pay statute might have a chilling effect on people bringing suits, and we don't want to put too much of a chilling effect on people bringing suits because some people have valid claims, and sometimes they don't always come out as quickly as you would like them to.
If it's not a valid claim, if it's genuinely a valid claim,
Yes.
wouldn't that concern be diminished?
Well,
I wouldn't worry about losing if I had a valid claim.
well, but every claim is based upon, are my witnesses going to be credible? Are people going to believe my witnesses? What kind of witnesses do I have? Can I get them to court? All of those types of things can bear some bearing on how valid a claim is. And so therefore, the validity of that claim has to do with the
Totality.
That's right. In other words, you can have a valid claim that loses. The fact that you had a loss doesn't necessarily mean you weren't right. It just means you didn't prevail on that trier of fact. You might have still had substantial evidence to support your claim. It's not a frivolous claim in the sense of that there's nothing to support it. Or very, very little. It's not grounded in law or in fact. And if a lawyer brings a frivolous lawsuit, they can be disciplined by the state bar, and have been.
Herb?
No, that was my question.
Bonnie?
The standard is a preponderance of evidence, not absolute proof. Is that right?
Yeah, well, in most civil cases, yes. Some civil cases have what is called a clear and convincing standard. And criminal cases have to have a beyond a reasonable doubt standard. And as I like to compare it, preponderance means you get the ball across the 50-yard line. And clear and convincing means you score a field goal. And beyond a reasonable doubt means you get a touchdown.
Brady Hamilton. I had a question.
Sure.
Lifetime appointments of judges. There's
Okay.
been example after example. Bill O'Reilly is often noted on his program for pointing out some of the more absurd judges that sit on benches around the country. What here in Virginia can or should be done about lifetime appointments?
Okay, the lifetime appointment only exists in the federal system of good behavior and in Rhode Island. In Virginia, we have something that you could call a modified form of a lifetime appointment. And here's why I say that. Circuit court and district court judges have 6-year terms, Court of Appeals has 8, and Supreme Court has 12. And almost always when they come up for reappointment, unless something's wrong, Nina Peace is a good example of that. She was not reappointed when their time came because enough people said they didn't like her for whatever reason. I don't want to get into the facts of that because I don't know enough about it. But enough people said the legislature decided not to reappoint her, and that's what the legislature can do to anybody if they want to. But most of the time, these judges are going to be reappointed so long as they don't get into trouble or cause a problem, get something like a DUI or something, as long as they don't raise some kind of trouble, they're going to get reappointed.
What
Now,
about if they're reversed, on appeal frequently?
well, a legislator can look at that. I don't know if legislators have looked at that in Virginia.
Is it a committee among the legislative body or the entire legislative body?
Well, technically it's the entire legislative body, but I will tell you right now that the way they do it in Virginia is the local delegation has tremendous clout in deciding local judges. So if you have a judge here in Hanover, they just appointed Hugh Campbell to be judge of the General District Court. What happened? 5 men put their, I think they're 5 persons 5 lawyers who were qualified, put their name in, asked the bar to endorse them. I went to that meeting, I voted, I supported the candidate, my candidate didn't win. But they voted and they said 3 of them were highly qualified and 2 of them were qualified. Went to the legislature. The legislature's basically going to turn around and say, Delegate Pease, Delegate Cox, Senator McEachin, Senator McDougal, Senator Scott, what do you think of these men? And they will have a lot of clout. And sometimes what they will do is they will get together and they will interview the candidates. And they will decide as a block how they will go. And sometimes they don't agree. 4 of them might say, I want ABC, but one of them says, I want DEF. But what the other members of the legislature is going to look at is they're going to look at that local delegation. So even in reappointments, the local delegation. Now for statewide judges like the Court of Appeals and the Supreme Court, everybody has a say, but the party in power in each house has a caucus, and their caucus will decide who they want as a judge for a statewide judgeship. And since the Senate is 20 and 20, and since judgeships are one of those things where the lieutenant governor cannot break the tie constitutionally, the Democrats and the Republicans kind of have to work together because it goes through both houses in order to be appointed. The governor doesn't have any say in it whatsoever.
We have time for one more question. Well, I have one. Okay. There's a general concern, and this goes on up above the Virginia level.
Right.
There's a genuine concern, and it seems to be growing in the country, that international law is creeping into...
You touched one of my buttons.
It's creeping into the superseding
Right.
of our sovereign
Right.
law.
You're
You
absolutely
touch on
right.
that.
You are absolutely right. He is right. And here's the problem. There are two places where this arises. One is from these UN treaties that keep getting passed or not passed. We've defeated a few of them. Thank the Lord for that. These UN treaties are passed by all these despots out there, and they don't mean a thing to them because they're not accountable to anybody for them. But they mean something here because the Constitution is the supreme law of the land, and the treaties and the federal law are the supreme law of the land right along with it. So therefore, you can have a problem that can arise because some judge somewhere can say that treaty gives defendants rights or gives children rights or something like that. And that's exactly right. And unfortunately, what has also been happening is sometimes the Supreme Court has been taking some of that international law and using it and saying, for example, that kids who are 16 and 17 can't be executed. Now, I'll tell you, I can show you some crimes that were committed by juveniles that were totally heinous crimes. And maybe they should be up for execution, but they can't be. Because the Supreme Court of the United States decided, in part because of international law, that 16 and 17-year-olds can't be executed. They don't get executed until they're 28 or something, mind you, because of all those appeals. But my point is that, yes, you're absolutely right. And that's why we have to be very, very careful with these treaties, because these treaties are positive law in the United States.
I have never seen this guy as long as I've known him this far about.
Well, you know I write for that blog.
And I'll tell you how I came to that question. And just as a fashion tip, I would not come to another Mechanicsville Tea Party meeting wearing a UN tie.
All right, fashion tip.
Just an observation.
I wore this tie because of the National Day of Prayer, and I thought it would remind people of missions around the world. So my intention was...